Hi, Tony DeWitt here, Missouri Appellate attorney and a guy who likes to make the law make sense on YouTube. You may have seen in the news recently where a certain person was having a plea deal and all of a sudden it fell apart. So I don't want to get into that because that's a whole big political issue and people tend to be on both sides of it, and there's no reason to be no reason to get into that, because what I want to talk about is the whole idea of plea bargains and how they work, why they might be good, why they might be bad. Let you make up your own mind on this. So let's get started. A plea bargain is essentially a contract, usually a written contract, between a prosecutor and a defendant. Usually it's negotiated by the defendant's counsel, although in some rare instances, defendants negotiate on their own behalf to get a plea bargain. And basically what it boils down to is that the prosecutors routinely overcharge their defendants. If someone is in a car and there is a firearm in the car, they might be charged with carrying a concealed firearm. Now, the prosecutor doesn't really have any hope of proving that because it wasn't found on the person of the defendant, but he can still charge anything he wants to. And then when he gets in front of the defense attorney who says you have no way of getting that done, he can say, well, how about unauthorized possession of a weapon, and we'll make it a misdemeanor instead of a felony. Because in almost all of these situations, you have a classification that goes from misdemeanor up to felony and beyond. And depending on how serious the crime is, prosecutors generally try and charge the felony if they can get away with it, so that they then have something to negotiate with if they have to do a plea bargain. Now, sometimes pleas are not bargains. Sometimes the prosecutor says, look, I will take a plea from you, but I'm not going to give you anything for it. There's no expectation on my part that I can't prove every element of this case. And so if you want to try this case, that's fine. Hire yourself an attorney and let's go to it. Otherwise, plead guilty and that's it. We're done. Other times, if a lawyer is involved, other times that can happen to a lawyer too. I mean, a lawyer could very well get the same message. But usually, the prosecution will attempt to deal fairly with you, though not always. In the criminal case that I tried, I had a client who was charged with one count of a particular offense. And the prosecution's demand of the client was that he plead guilty to that and that he accept whatever the court imposed. And they said, if you don't take that deal, then here's what's going to happen. We're going to indict you on a total of 5 counts, and then you'll have to deal with 5 counts in this case. So he decided that he could absolutely try this case and win it, even though I told him there was no way in the world that he could win this case. And he got indicted for 5 more, and he wound up getting convicted on all 5 of those charges. Fortunately for him, the judge ran the sentences concurrently instead of consecutively. Otherwise, 5 years on each of those counts would have had him going to jail for 25 years. And that would have been a pretty ugly thing for him. So the deal is, if the prosecutor has any leverage or any room, they will use it. And if not, they will try and reduce the elements down to whatever they think the defendant will plead guilty to. Now, a lot of times people want to plead guilty to a misdemeanor as opposed to a felony, because a felony brings with it a whole host of disabilities, civil disabilities. There are a lot of things in a lot of states you can't vote if you're a felon. A lot of states you can't serve on a jury if you are a felon. There are all kinds of civil disabilities that come with being a felon. And as a result of that, the people who understand how the system works want to try very hard to avoid getting hit with a felony. So they try and plead to a misdemeanor. In the firearms world, it doesn't matter whether it's a felony or a misdemeanor, because if the potential sentence is greater than 1 year, in other words, if the state of Ohio says that this crime is a misdemeanor, but the judge could give you up to 2 years in prison, then it is not considered to be a misdemeanor for federal gun charges. In other words, if you got convicted of that misdemeanor and then went to buy a gun, you'd be violating the law because the sentence was greater or could have been greater than 1 year. So there's all kinds of reasons why people might want to plead to a lesser charge in order to escape the disabilities that come with those kinds of things. I'm going to ask you a question, and I'd be really interested in how many of you get something close to the answer here. How many cases do you think end up in plea deals? Give me a percentage, 5, 10, 15, whatever you think the percentage might be. How many criminal cases wind up in a plea deal? Because I think you would be shocked to learn exactly how many there are. Now, the parameters of a plea deal are fairly specific, meaning that either side can non-perform. For example, if the plea agreement says that you're going to plead guilty to a misdemeanor charge of public intoxication, and you agree as part of your plea deal to go to Alcoholics Anonymous and get therapy for your drinking disorder, and you don't follow through on that, then the prosecutor can come back and he can strike the deal and take you to trial on the original charge. Your plea of guilty goes away and you now have to defend that charge in open court. Similarly, if the prosecutor says we're going to amend this citation down to defective vehicle equipment, and instead they charge you, or they make the charge a misdemeanor of street racing, because that's actually what you were charged with, and they violate the terms of the bargain that they reached with you, then again, the defendant can go to the judge and say, this isn't what I agreed to. And apparently in that recent case, that's sort of exactly what happened. The defendant found out he was going to be agreeing to something less than what he thought he was getting. And I fully support his right to absolutely take this to trial if that's what he wants to do. I think it's an important right to be able to take something to trial. But here is the interesting thing about plea agreements, and this is in the federal system as well as the state system. Prosecutor says, okay, you've been charged with aggravated assault. We're going to plead it down to simple assault over here, and we're going to recommend a sentence of up to 1 year in jail. And they go up in front of the judge, and the judge says, okay, now you have to allocute, and you have to tell me, are you guilty of this crime? Yes, I'm guilty of that crime. Okay, tell me what you did. Well, basically, I pulled out a gun and I pointed it at this guy, and I told him that I was going to kill him. Well, at that point, you've just allocated to something a lot worse than simple assault. And as a result of that, the judge doesn't have to accept the plea deal. The judge can say, no, this is not in the interests of justice to accept this plea deal. We are not going to accept this plea deal. You guys go back and try and work something out that is something like substantial justice in this case. And judges usually don't do that because usually prosecutors have had a chance to prepare their defendant to do what he's supposed to do, and something like that doesn't come up. But it can come up, and the judge can just look at the terms of the plea deal itself and say, no, I'm sorry, I'm not approving this. And even though the prosecutor says, look, we're not seeking a sentence of greater than 1 year, the judge can look at it and say, no, I don't think 1 year is enough. I'm going to give you 4. And at that point, the prosecutor has performed his part, and the defendant has performed his part. And as a result of that, there is really not a whole lot that anyone can do about the fact that the judge who oversees this process is refusing to honor the explicit terms of the deal. Now, the defendant can ask to withdraw his plea, And if he has a good reason, sometimes the judge will let him. But it's always up to the judge. The judge is the ultimate decider. And frankly, that's how you want it to be. You want the judge to be the ultimate decision maker in this situation. And the reason you want that is because you want somebody overseeing the justice system as a whole, making determinations on the basis of everyone. One of the things that judges look at is whether or not other people have been treated more harshly or other people have been treated more leniently for the same offense. And if that's the case, the judge can, again, make adjustments to the plea deal if the judge believes that that's necessary and if the state law allows it, or in some cases, if the federal law allows it. Now, I asked you earlier what you thought the actual number of cases were that might be going to a plea deal. In the federal system, 98% of the cases are resolved by plea bargain. 98%, meaning there are very few trials for criminal cases in the criminal system in federal court. And that's because the penalties in federal court are much more draconian. If you get sentenced to prison, for example, in Missouri, you may very well have, if you have a 5-year sentence, you may very well get out after 3 years based on their good time credit system and also based on how overcrowded a particular prison is. On the other hand, if you get sentenced to 5 years in federal prison, you are going to do 4 years and 6 months in the federal prison and then the last 6 months in a halfway house. That's the way the system is arranged, because if you get 5 years, and actually they don't give you years in federal system, they give you the number of months that you're going to serve. Based on those number of months, you're going to get all but the last 6 inside a prison. And anybody who is sentenced, I think it's more than 2 years in federal custody, can be sentenced to what they call a big boy prison. There are a number of different kinds of prisons in the federal system. There are basically just work camps, which is, dormitories surrounded by razor wire and you can't leave. And there's guards and all of that, and it's not a nice place, but it's not nearly as bad as, for example, the Federal Correctional Facility in Atlanta, which is basically a really dark, dank place and an awful place to be a prisoner. Same thing with Fort Leavenworth, not Fort Leavenworth, with Leavenworth, Kansas, the federal penitentiary at Leavenworth, Kansas. There are actually 2 Leavenworth penitentiaries. The Leavenworth at Fort Leavenworth is called the U.S. Military Disciplinary Barracks, which is where people who break the law in the military go. And then the federal penitentiary is Leavenworth Penitentiary. And if you can't make it in the military disciplinary barracks at Leavenworth, the ultimate penalty is to send you over to the federal penitentiary, where things are much worse than they are at the disciplinary barracks, which itself is no picnic. I actually had the opportunity when I worked in the Army to have to go to the disciplinary barracks. Our ROTC entity, we took our ROTC uniforms over there and had them cleaned, because one of the industries that they operate at the disciplinary barracks is a dry cleaners. And at the time, it was in the old building, and it was a very serious looking place to have to go in. And I was really happy to get out of there when I got out of there, even though I was only delivering laundry. I think the last thing in the world you ever want to do is wind up behind bars. It can be a pretty awful experience, I'm guessing. So that's what I have for you today about plea bargains. Hopefully you found this interesting, helpful. Maybe you understand a little bit better about how things go in a plea agreement. If you have any questions, leave them in the comments down below. Like, share, subscribe, you know how all that works. And sometimes it's good to remember that there are people in prison, and that even though they are prisoners, they are still people. And so if you know someone who has been sent to jail, write them letters. Those letters mean a lot to somebody who is in the pokey. And that is a kindness, again, that only you can do. And I can assure you, when that person gets out, they will remember that kindness. Thanks again for everything that all my subscribers do. All of the participation is greatly appreciated. Have a marvelous day and catch me down here at the beach next time. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.